I will present Dr. Karolina Wilamowska. Is that correct? Yes. Okay. Dr. Karolina is attorney at law and certified mediator. She's graduated law at Nicolaus Copernicus University in Torun and attorney apprenticeship at District Bar Association in Bydgoszcz with honor graduated Center for American Studies at Warsaw University. She is an author of publications on civil and criminal law. She managed a law firm Wilamowska advocacy, and she attends doctoral studies at Lanzarsky University. You have the words. She will talk about mediation as a key to parental responsibility, the legal perspectives on joint parenting in Poland. You have the word.
Thank you. Thank you for having me here, and I'll try to focus on some important issues on mediation. I'd like to start up with the fact that mediation has emerged as a significant alternative to the traditional litigation process, especially in family cases. In Poland, the legal potential of family cases is what we can, as mediators and also as professionals, see every day. Today, I'd like to show you the legal perspective of joint parenting in Poland and to emphasize the crucial role of mediation, as mediation can play and is trying to play in fair and equitable resolution for all parties involved. At first, I'd like to start up with some statistic. Although it says that there is lies and statistics, but I think that statistics show us what are we talking about. And what's the situation in Poland? And in Poland, we have every year almost or about 150,000 marriages and 50,000 divorces. 30% of marriages is finishing by divorces, other by death. And what is the most significant, I think that almost 60% of divorces cases finishes with the court sentence on joint parenting. And as you see, there are only 4% when the father is the main person in the marriage, in the custody. Is it a lot or not? I believe if we think as about the joint parentship, shared parentship as the main way of ruling of the court, this is not. I think that the percentage should be on much higher level. But what's the problem for that? I think that I think that the main reason is the legal framework. In Poland, we do not have the legal definition of parental responsibility. Even if we try to be specific, in Poland we do not speak about responsibility, parental responsibility, but we talk about parental authority, because parents have the authority over the children. It is the fact that one of things that we, as mediators, as professionals, would like to change in our law system. But what's is what it is parental responsibility under Polish law. It's a set of obligation and rights, as in many other countries, and they have the purpose to take proper care of the children and their assets. The concept of parental responsibility is governed by family and the guardianship court. According to this according to this piece of legislations, both parents are responsible for upbringing, care, and overall well-being of their child, irrespective of their marital status. In case of separation, divorce or parents who live separately, joint parentship is the default arrangement. As Polish law emphasizes the importance of both parties and both parents in being actively involved in the children's life. However, if the parents cannot agree on how to exercise their parental responsibility, the court will intervene and make the decision which is going to be based on the best interest of the child. And where is the place for mediation? As I said before, mediation is much more popular, and its role is increasing in family cases, and especially when we talk about child custody and parental responsibility. Mediation is a voluntary and confidential process in which an impartial third party, the mediator, helps the disputing parties negotiate and reach a mutually acceptable agreement. The main advantage of the mediation is that it provides a less adversarial and more flexible approach to the dispute resolution compared to the traditional litigation. This is especially beneficial in family disputes because it can help the parties to prevent the relationship between parents and allow them to cooperate more effectively in future to the benefit of their child. In Poland, many courts encourage and sometimes even order parents to participate in mediation before proceeding with the legal process. Unfortunately, the mediation process still is not mandatory. So, what is more, there are no legal mechanism that allow the court to demand that people who are in mediation really would like to talk and not to treat this mediation just as the way to show that they want it. And I think this is the main problem. Although I believe that as a mediator and as a professional in such cases, I believe that there are many reasons why mediation is much better than litigation process. In mediation, parents can decide on issues which are not possible to be decided during the court procedures. For example, they can decide on the allocation of sorry, I forgot about no, not okay. The allocation of parental responsibilities and decision-making authority, the child's living arrangement and visitation schedules, financial support and child maintenance, the child's education, health and religious upbringing. Courts decide just on the most important issues. They don't allow, they don't put in the ruling the most interesting aspects of everyday life. So it's easier for them to decide on giving the full responsibility to one parent and not decide on the issues that are connected to them. Moreover, mediation agreements reached in the course of family disputes are legally binding, provided that they are confirmed by the court. This makes this ensures that the arrangements are enforceable and respected by both parents. It is said that even the worst settlement is better than the best sentence, because this is what we decided on as a parties. And what are the benefits of mediation? First, it's reduced emotional stress. Mediation can help parents avoid the emotional trauma associated with traditional litigation, which can be especially beneficial for the child, which is going to be the part of this process. The, cost effectiveness. Mediation is generally less expensive than traditional litigation, as it requires fewer court experience and less time spent on legal procedure. It doesn't need also the parties to be represented by professionals, so they do not have to pay the cost of such a representation. In Poland, mediators prefer when the party is not represented by a professional, because professionals sometimes are disrupting the process of mediation. Faster resolution. Mediation, okay, I don't know. Okay. Mediation can lead to a faster resolution of disputes, allowing parents to focus on their child's well-being. In Poland, it's very long process on parental responsibility. Sometimes it lasts a few years. So if at the beginning we have a child and a mother who doesn't allow the father to take care of the father, after a few years it's almost impossible to the child to still have such a relationship that allows a joint partnership and joint custody. Faster resolution, greater control. Mediation allows parents to retain control over the decision-making process rather than leaving it to the judge. As I said, if we decide on something, we can put every issue that is important for us into the settlement that we are going to take. Improve communication. Mediation can help parents improve their communication skills and foster a more comparative parenting relationship. I can tell you one situation that I had lastly. It was two parents who decided on mediation process, and they couldn't find the settlement that was satisfied during the court process. But then they started to talk to each other. And a few weeks after our mediation, where they didn't get the settlement, they called me and told that although they didn't prepared enough at that moment to take this settlement, this situation for them was the beginning of the process of getting back into communication. So the most important during the mediation process is that the parties started to communicate. They started to see that in this process there is a child, and the child is going to be the most important part of this process. In court, we sometimes forget, as professionals, as parties, we forget that we are fighting for the benefits of the child. We're fighting with the other side. And what is my conclusion? Mediation plays a crucial role in promoting joint parenting and parental responsibility in Poland. By encouraging open communication and cooperation between parents, mediation can ensure the best possible outcome for the child while maintaining a positive and stable family environment. As Polish courts continue to recognize the benefits of mediation, it is likely that this approach will become increasingly prominent in family law cases involving parental responsibility and joint parental agreement. I think that there is still a lot to do. We need to decide where is the role of a child in this mediation process, because still it's the problem that still is the problem that the mediation is a process between parents. And we are working in Poland on putting the children into the mediation process. There are many different ways to do this. We are talking about a special person who is going to represent the interests of the children or the child during the process. And even some mediators are taking the child to the process. They are, for example, talking to this child with a psychologist who helps to understand what are the child's problems, what are the child's what the child would get from this process, because as it was said today, we need to focus on the child. We need to focus on what the child would want. Because I think that the main problem in Polish law is that the courts think if the parents cannot communicate, there can't be a joint partnership, joint shared part, yeah. And if sometimes the people can communicate, but in court, their decision is to say it is not possible. And I had such a situation lately when a mother during the whole process told it is not possible for parents to communicate and to boldly decide on children's issues. But the process took almost 3 years. And during these 3 years, the children were in shared partnership. So and they could communicate. They, of course, they had different kinds of their insight into the parental responsibility, but the children were great in this process. So after 3 years, at the last case in the court, the mother said it is not possible to be in joint custody because we cannot communicate. But the psychologist during the process told it is the best way to guarantee the children's benefits in this procedure. So the worst what courts can do is to think is just to decide on one person decision, because especially mothers decide that it would be better for them if the father is going to be just a person who sometimes visit their children, and to have the sole custody under their children. So this is the thing and the problem that we need to deal with. And I think that we also have to decide how to educate society, because people who are in mediation process, are in litigation process have no idea about consequences of the decision made during this process. And also we need to educate judges, and especially family judges, professionals, to support the mediation, to support the shared custody. There's, I don't know, during my 10 years career as an attorney, I had 2 cases when judges decided on joint custody. And I had hundreds of cases on this issue. This shows that judges are afraid. And if only they hear that people are in conflict, they decide that it's not possible to give them the joint custody. So although we change the attitude of the judges, we give them the mechanism that will allow them to know what these issues are. I think that it's going to change. So I think that such events as today conference should be conferences that all professionals, judges, mediators should attend in to see how is it in other countries. There are countries where mediation is mandatory in family cases. In Poland, we have every 2 years we decided to try mandatory mediation, but still it's not mandatory. And even if we have in our code said that people must try to the ADR before process, it's sometimes it just writing and sent a sentence that it wasn't possible to communicate the other party, and judges allow to put the case to the litigation process. So thank you very much.